Hello. Today's presentation is brought to you by Family First Legal, presented by yours truly, Utrice Walker. Today's presentation will give you an overview of the differences and the similarities between an absolute divorce and a limited divorce in the state of Maryland. To begin, we're going to look at the effect that each type of divorce will have on a legal marriage. An absolute divorce, as its name alludes to, terminates or ends a marital relationship absolutely. At the end of a divorce proceeding that is an absolute divorce, the parties may remarry because the marriage that they previously had has been completely severed. A limited divorce, differently, is more like a legal separation. It does not terminate the marriage, and parties may not freely remarry. There are benefits and drawbacks to both types of divorce. Let's look at the effect that each type will have on property. Absolute divorce is where property will be separated into categories and then distributed according to the category it falls into. For example, if a piece of property is deemed to be a separate piece of property, that means it belongs to one party or the other party, and that it is not marital property or not joint property that needs to be divided. However, marital property will be property that the court will need to divide in an absolute divorce proceeding. And you'll see here that I also included the word mixed property. That's usually where the parties are in disagreement about whether the property is separate or marital, or even if they're not in disagreement, there may be portions of a piece of property that is separate and portion of the same piece of property that's marital. And that can happen for different reasons. One of the major reasons being that the property was purchased prior to the marriage, but then brought into the marriage. So the portion of it that was bought and paid for at the time prior to the marriage would be separate property, if it could be split that way. And then marital property would be the portion of it that was brought into the marriage. So the understanding of property can be a little more complex than that, but that's the simplified version of that. In a limited divorce, differently from the absolute divorce, property is not separated. In fact, it is instead, the court will look at it to determine the use and possession of such property for a limited period of time. Usually the limited divorce will give a period of time between 12 months and 3 years, where one party may be able to use and possess certain marital property. The effect on custody, child support, and alimony of both the absolute and the limited divorce will be very similar. The biggest difference you will see in the impact between an absolute divorce and a limited divorce is going to be in the alimony category. While you can receive alimony or spousal support in both a limited divorce and an absolute divorce, only the absolute divorce can award you with permanent or long-term alimony. But generally, all of these terms, unless otherwise agreed to, will be modifiable. And even in an agreement, if custody and child support are intended not to be modifiable, the court will always consider custody and child support to be modifiable based on the circumstances. But alimony, if the parties agree that it is not to be modified, it will not be modifiable, or vice versa. Now, how do you decide which of these is going to be the best for you? So the absolute divorce is usually for someone who wants to terminate their marriage and have long-term decisions made about the property and alimony and other issues of marriage. These are people who are going to meet certain grounds. Do you meet the grounds? And usually the grounds for absolute divorce are going to have a time limit on them, like 12 months. Particularly unless they're under the mutual consent ground. And you must have lived in the state for at least 6 consecutive months prior to filing, or your spouse must have lived in the state for at least 6 consecutive months before filing. In the limited divorce, which is what makes it a little more appealing, is that if you don't meet the statutory grounds for an absolute divorce, you may actually meet the grounds for a limited divorce. The limited divorce generally has no statutory amount of time required for holding grounds, such as the amount of time you need to be separated. The statutes actually say that it must be for a reasonable amount of time. And similar to the absolute divorce, you must live in the state, or your spouse must live in the state for 6 consecutive months prior to filing. And you would file this limited divorce usually if you're thinking, I need to get some financial support right now. I need custody right now. I need to use and possess the home without my spouse living here. These are things that you may not be able to do if you don't have grounds for an absolute divorce. So the limited divorce gives you the ability to do that without yet being able to file for an absolute divorce. And some people would choose a limited divorce over an absolute divorce because they're not quite sure they want to be divorced or that they want to terminate the marriage. And in that position, they may decide that trying this trial period of separation, but having some stability of the financial support, the use and possession, which is allowed in a limited divorce, gives them the opportunity to decide if you're going to move forward with the marriage or if you're going to move forward with an absolute divorce. So this is a brief overview of the differences and the similarities between an absolute divorce and a limited divorce. If you are interested in finding out more information about either the absolute divorce or the limited divorce, please look at our other learning modules. Check us out at www.fflmd.com for more information on any of the topics that are presented. Thank you.